Welcome to Middle Class Matters. Today we will see an important issue on Adani's company's issues. That is Supreme Court Committee report. That is Supreme Court has directed on 2nd March 2023 by forming an investigation committee to look into the matters of the Adani and Hindenburg report. The committee has submitted reports on 6th May 2023. Let's see the executive summary of the report. The SEBI to investigate. The SEBI has been directed as per the executive summary. The SEBI has been asked to investigate first, violation of rule number 19A of the Securities Contracts Regulations 1957 SCRR regarding minimum public shareholding, because as per the SEBI rules, any company which lists the securities in these stock exchanges should issue 25% shares to the public. It can be general retail investors or financial institutions, and the promoters are supposed to have only 70 to the extent of 75% of the company's shares. They can have less than 75%, but they cannot have more than 75%. Point number 2, failure to disclose transactions with related parties in accordance with the existing laws. Related parties transactions is one of the important areas through which the companies manipulate their transactions. So that is why this also has been asked to look into. SEBI has to conduct an investigation. Then third point, manipulation of stock price as per the existing laws. Whether Adani group of companies have manipulated their share prices as per the existing laws. Expert committee requirements, the remits, that is the directions given to the expert committee, or as per the page number 2 of 173 pages. First, factors led to volatility in securities market in the past. Second, regulatory failures pertaining to securities market by Adani Group and other companies. C, measures to strengthen investors' awareness. D, suggest measures to 1. Statutory or regulatory framework. Second, secure compliance with the existing framework for the protection of investors. So these are the requirements which have been given by the Supreme Court to the committee which has been appointed under the retired Supreme Court judge with the experts in the field of stock market and the other related fields. The expert committee took briefing from, as per the third page, the expert committee took briefing from 1. Securities Exchange Board of India SEBI, 2. market participants, maybe mutual funds and other investors. Then 3. Directorate of Enforcement ED. 4th, Central Board of Direct Taxes, that is Income Tax Department. 5. Investment Protection and Education Fund Authority. This is for investor education, for the purpose of investor education. Findings of the Supreme Court Committee, which is seen in page number 4. The first point which has been looked in by the committee is on volatility. Point number 11 says, the committee concluded, based on empirical evidence, that the Indian market as a whole was not unduly volatile during the period under reference. Comparison of Indian Volatility Index, Indian VIX, with CBOE Volatility Index, CBOE VIX. The volatility in the Adani stocks was indeed high, which is attributable to the publication of Hindenburg report and its consequences. So the Supreme Court has not found any volatility, the major volatility in the stock market during the period of its investigation. The second point is on investor awareness. This has been point number 12, which is given in page number 5, between 2019 and 2022. Point number A, Out of total trading by individuals in the cash segment, 67% value is by way of intra-trade deals and only 33% result in delivery of shares. So that means that the speculators are taking a major portion. 2/3 of the market is by speculators, intra-trade trade. Only 1/3 is by the investors who are taking the delivery of these shares. Second B, total number of unique individual traders who traded through top 10 brokers in equity F&O segment has increased by over 500% in financial year 2022 compared to financial year 2019. So that means that fivefold increase is there in the individual traders who have traded through top 10 brokers. Point number C, 88% of the individual traders were active traders. So individual traders were whether speculators or investors, they were very active. 88% is active in the market. Point number D, 89%, that is 9 out of 10 individual traders in equity F&O incurred losses with an average loss of rupees 1.1 lakh rupees during financial year 2022. So that means that whether they were speculators or investors during the year 2022, 9 out of 10 individual traders have lost in the market to the extent of average loss per individual trader was rupees 1.1 lakh crore. This is a very serious finding by the committee. This should be looked into if we have to encourage the individual traders to participate in the stock market operations. If the individual traders loss is minimized only, it is good. That means that the individual investors awareness has to be increased and market disclosure requirements and the company's insider trading, all these things have to be avoided so that the individual traders will not lose. The average loss per individual trader has to be reduced. In fact, the average trader has to, on an average every year, they should make at least a return from the market. E, despite such losses, share of individual traders in total F&O turnover is very high. During the last 4 years, 27 to 29% increase average per year has taken place. In spite of losses, individual traders were participating in the market without much worried about their losses. Page number 6, point number 13. SEBI has recognized the increasing number of intraday traders. Areas need attention and strengthening. So SEBI has taken note of this and it is taking attention for doing strengthening of the rules and regulations. Point number 15. The Indian securities market works on a disclosure based regime and issue and regular intervals. These disclosures are done by the listed companies in the stock exchange while listing as well as on a regular basis. As and when any material information happens in the company, that has to be intimated to the Securities Exchange Board of India. Point number 16. Disclosures that load the investors with so much data and noise that the real content necessary to make an informed decision may be lost. What the companies are doing is they load the SEBI with so much of information which are unnecessary to make informed decisions. So it is pertinent for the SEBI to give what type of disclosure to be done, what is material information and what is not material information, so that the material information will seek the attention of the investors while investing, thereby they will not lose. If the disclosures are being made properly, the average investor loss for the financial year 2022 could have been reduced from rupees 1.1 lakh per individual investor. In the page number 8, it has been discussed on regulatory failures. Point number 20 was repetition of the page number 1. Then the next point which is discussed is minimum public shareholding. Point number 21. In case of Adani Group companies, the issue of minimum public shareholding is dependent on whether 13 overseas entities, including 12 FPIs, foreign portfolio investors, are disclosing of their beneficial owners as stipulated by law. So that means that the committee is not able to give the opinion because on the minimum public shareholding, because the 13 companies which have FBIs, 13 overseas entities which are under investigation, which is not completed, they are not able to give an opinion whether the last mile, the last beneficial owner, economic advantage owner is identified or not. SEBI has not been able to identify. Point number 22. SEBI FBI regulations 2014 had mandated means it's a requirement, basic requirement, a requirement to disclose the ultimate beneficial ownership by natural persons above the FPI. The natural persons of FPI must be disclosed, which is mandatory. This was part of a provision that dealt with opaque structure of ownership of FPIs. In any case, the declaration of the ultimate beneficial owner under SEBI regulations was required to conform to the disclosure of beneficial owner under the Prevention of Money Laundering Act 2002 PMLA and thereby Rule 9 of PMLA Rules 2004. Point number 23. 3 facts are clear. Fact number 1. FPIs in questions have made declarations of the beneficial owner by identifying natural persons controlling their decisions for purpose of PMLA. This is the declaration that comforts to compliance with FBI rules. Guarantee, that is fact number 2. The very requirement to disclose the last natural person above every person owning any economic interest in FBI was done away with in 2018. As per the amendment of 2018, SEBI has relaxed this rule, opaque person rule, pursuant to a recommendation of a working group, and the provisions on opaque structure was deleted on the premise that declarations under PMLA constitute sufficient compliance. So SEBI has working group has given the recommendation that declaration under PMLA is enough, opaque structure requirement is not required. This was removed in 2018. Fact number 3. SEBI was investigating 13 overseas FPIs from October 2020 despite legislative changes made in 2018. Even after making the changes in 2018, SEBI, because of having some suspicion, has been investigating these 13 entities for their real owners from 2020 on October 2020 onwards. Point number 24. SEBI has found 42 contributors in the assets under management of 13 FPIs. So for 13 FPIs, there were 42 contributors. SEBI has referred the matter to Directorate of Enforcement, Central Board of Direct Taxes, and various regulators in 7 countries. Even after referring these matters to this, for past 3 years, almost 2.5 years, SEBI is not able to come out with any conclusion. SEBI has drawn a blank because ED has told that unless otherwise they file a case under the PMLA Act, it is not possible for them to investigate, further proceed in that case. They cannot elucidate information from foreign countries. Income tax rules also, double taxation avoidance agreements also, income tax department cannot, unless otherwise they file a case against Adani Group, they will not be able to get any information. Even through the other, say the regulators in overseas countries, SEBI is not able to get any proper information. So far SEBI has not got any information whether the who are the beneficial owners of these 13 FPIs. 27, point number 27 in page number 10. In spite of best efforts, SEBI is unable to satisfy itself about the suspicion of wrongdoing. The records reveal a chicken and egg situation. That means that SEBI is not able to satisfy itself, or say if it is satisfied it can give up, but it is not able to get the information because of various reasons. Unless otherwise a case is filed against Adani groups under PMLA Act or under the Income Tax Act, they are supposed to register a case against the Adani group companies, and they should conduct the searches. IT department has to conduct searches, and then IT department should find out some disproportionate assets, disproportionate income. Then they can give it to the enforcement directorate under the PMLA, Prevention of Money Laundering Act, because money would have this disproportionate income will be through foreign exchange. Once foreign exchange is involved, then it can be given to enforcement directorate. They can register case under the PMLA, and then they can approach the various countries for getting the information about these 13 foreign portfolio investment companies, who are the actual natural persons who have given the money for bringing the money and investment into Adani group. In this point number 28, in these circumstances, the committee is of the view that it would not be possible to return a finding of a regulatory failure in relation to compliance with the regulatory stipulation governing minimum public shareholding stipulation. That is, now the Supreme Court committee has come out with a conclusion that they are not able to give their opinion. They are not able to give their finding whether the regulatory requirements have been met or not. The next video we will see on the related party transactions of Adani group. Please like the video, subscribe to the channel, give your comments. Thanks for watching.